Besides this is obviously going to be. If you want to know what really happened, you need to watch this. This is the only place you're going to get this type of interview or
I don't really know what this is, but I didn't do it. I'm innocent, Judge. I'm not guilty. I'm innocent.
We, the jury, being duly impaneled and sworn, find the defendant Matthew L. Moore not guilty of murder as he stands charged in count 1 of the indictment.
How are we doing? Let's go. How are we doing, people? Hope you're all well out there. I'm just waiting for the stream to start, but it's a Thursday. It's a great day. We got this trial, we got Kariga trial, we got what's going on. It's going to be a good day today. I can feel it. Christine, hello, Christine. How are you? Sarah P. Welcome everyone. Thanks for joining. Please hit the like, subscribe, and hit that notification bell. Notification bells are funny things because last night I went live with the Kohlberger stream, and it took like 10 minutes before I got a notification to say I was live, which is weird. But then now it took like 30 seconds to get today's one. I don't get YouTube. I don't get it, but it is what it is. Join the Auto Corner community. You can become a member if you want to do so. A lot of people became members yesterday, so I appreciate you all for that. Go to the members tab, see you can get access to Discord and also some other videos and stuff there. I need to do another members only video coming up, I think. Check out the merch store, and finally but not least, I don't know what that means. Hang on, what's that notification? Finally, but not least. No, that doesn't make sense. I don't know how you say it. Last but not least. If you want to help the channel out, help me out, then please consider supporting the channel through PayPal or buy me a coffee. I find for Americans, buy me coffee is better. I think for Americans, they prefer that one. PayPal for UK and stuff. Never required, but always appreciated, as they say. Here she is. Hello, Josie Medallion. How are you? Hope you are well as well. I know you've not been following this trial, I don't believe, but we are on this trial. It is I believe the state are arresting first thing this morning. Then I believe, I'm not sure, well, actually, I don't believe anything. I'm not sure if the defense are going to do anything, put any witnesses on or anything, so we'll see that. And then they're going to do jury instructions and closing arguments. So it could be over today. If it's not over today, it'll be over tomorrow, is my prediction. So there we are. We've got that. And also, we obviously got the Kariga trial, which is getting spicy. It's getting spicy in Kariga. That is, the prosecution should be resting next week on that one. So I'm excited about that. So we'll watch a bit of that later as well. But there's never any Kariga trial on Fridays. So I'll be doing a Karen Reid stream tomorrow. I'll be doing one of those streams for those that don't really know much about the trial. So yeah, I'm still waiting for the stream to happen. There's nothing going live yet. So never fear. You're not missing out on anything. Nothing whatsoever. 6 people, 4 likes. What's going on? Why is that like that then? No, nothing there. Right. I think they start about 9 o'clock, 9:05. So that's what happened yesterday. I got the link at like 9:05. So never fear. If there's a link for this stream, I will get it. Why? Because I'm a hero. Happy days. Oops, that was me. No, it's fine. Other people are the same. I don't understand quite understand, right? I always want people to chat in chat if they feel up to it, if they feel they want to. But for some reason, this trial, no one wants to chat. So don't be scared. We don't bite, honestly. Why is it? I've got a black screen now for the stream. Why have I got a black screen? Yeah, chat with us. We're really friendly, really are. I'm not sure if you're here generally just for this trial or what, but you know, we are nice. We don't bite. Even if you just say hello when you're working, it's all good. Don't be shy. No, don't be shy. I always give Sarah P as a person example. She was always shy. Look at her now, can't shut her up now. Josie's never been shy. Josie doesn't even know what shy is. If you look up in the dictionary what shy is, you don't see Josie, that's for sure. If you look in the dictionary about talkative, that's where you see a picture of Josie. So oh. Exactly. Hi Christine, how are you, my darling? Please go follow Christine as well. Christine has got a channel on YouTube if you want to follow Christine. I will you can follow Christine, just put Christine Fortunato in chat into search and she comes up. You can do that. So please go and follow Christine. She's going to be doing some interviews with, I believe, Matt and with Solomon and Wendy and a few others, I believe. So always worth a follow to see our lovely Christine there. You haven't seen for ages Mary Viviano. Not seen the Viviano for ages. I know she didn't like the Carrega trial, so I don't think she left us for that. So she's not come back. So I always, when I see Christine, I always think of Mary Viviano, half Italiano, but I haven't seen it for ages. I got this today as well. You can see it. You see that? It was a free gift. It's a little boy hat. They were. I obviously bought some this stuff and I donated some money to the car refund. Just obviously donated some of that, and obviously I donated more than what these were worth, and they sent me a prototype, one of one hats. So I should wear it. Well, I don't wear hats, but um, yeah, it's lovely. It's lovely, lovely and soft. Yeah, I got a few hats around here. I bought another hat yesterday, but yeah, this is from the Turtle Boy store, so you can get that there. Oh no, you can't get this there. It's not in the store, but you know you can get these in the store, and you can help donate and help contribute towards Karen Reed's fund. Oh, I'm advertising more about other people's merch stores than I do my own. Oh, come on. I can't hide Sarah P's thing. Can't hide that. Oh, bollocks. That's Josie, that's Sarah P, and that's Mexi, so I can't put that there. I have to put that. Doesn't hide anything, does it? Nope, that's fine. Hi, Christine. Always happy to see you. To see you. Right. So yeah, lovely to see you, Christine. Right. Why? Right. Hang on. It is now 1 minute past. So they will be. The stream should be starting soon. I will just go and check. Come on, Eileen. Someone, Eileen. Dee, 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 dee. Come on, Eileen. Ah, dee, 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 dee. No, not that one. I'm trying to find. It's not really working. I'm trying to find the link. And I just did a boo boo. Why is that? Oh, I've done something. I'm not sure what I've done. Okay. Well, I'll just leave it there for a sec. It should. Once the call starts, I should get the stream. If I don't, I don't know what to do. Let me just look for another backup then, just in case. It's a hard knock life for us. It's a hard knock life for us. Oh, uppy, oh. Oh, oh, oh. McDonald's slipping down, right? Okay. So I'm just gonna try and find. I can't multitask, you see. So here it is. Where is this gone? Life update. Ooh, 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 ooh. That's the one. No, that's not the one. Dee, 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 dee. So I look and see if there's anything live. No. Right, I've got the link. So I be patient. Yesterday we had to wait 5-10 minutes before we went live, so we'll just have to be patient for a little bit. It's all good. It's all gravy, baby. There's not much we can do about it. It's fine. I'm starting my 11K a day steps tomorrow. 11,000 steps a day. Starting that tomorrow. I've been avoiding doing much walking, um, because I do want to be too sore. But I'll probably be sore tomorrow. It's 11,000 a day steps a day for 31 days. As it comes up now, we'll see. Thank you to everyone who's donated. Josie, the first one, very generous donation. Yeah, I'm £21 short, but that's fine because my parents haven't given me any money yet, and they will be donating. So I put a target of £250, which is around $300, which I think is realistic, and I'm I'm basically $30 short, but my parents have they will be donating for it. So, and I'll still share it if people do want to donate after that. That's fine. But I'm just glad to reach my original target, which is good. Got my T-shirt over there ready for tomorrow. I'm not even sure I'm going to do this. Do you know what I mean? I got to walk her inside. I've got to walk outside of it. I don't know. We'll see how the weather's like. But yeah, I'm looking forward to it. What I'm not looking forward to is this bloody trial. Why is it this? Hello, hello. Where are you? Hello. Let me in the day. Normally, it does go straight to the court once the court goes live, but tomorrow, tomorrow, we love you. Tomorrow, tomorrow's a day away. Hey, hey. Okay. Live stream. Come on, Irene. Something Irene. Dee-dee-dee-dee, dee-dee-dee-dee. Yeah, no, we're not having any luck so far. So Maybe the delay is because yesterday afternoon the court there's nothing going on. Maybe the delay is because you know I don't know. I don't have a Scooby Doo why there's a delay. I don't know what. I don't know what. I don't know what. I can see the streams, but there's like a news channels and stuff like that playing stuff, but not the stream. Hang on. Let me put this on. Maybe I can hear something. Hmm. This is the worst part about when you're the only streamer doing this stream. I hold that record, I think. I'm currently streaming 2 trials, both of which I'm the only one on the whole of YouTube streaming it. How do I get myself into these pickles? Oh dear. I should just stick to the bigger ones. The trouble is, if we do all the big trials, I get eaten alive. Because they all do the same ones. As like, you know, also I want to be different. The Krieger trials, a quadruple murder one. We're still doing that at the minute, day 44 today. I obviously regret doing it to some extent because all the bullshit that goes into it. But I'm glad we did it because we met loads of nice people in Kitsa. So it's also quite good. But I did this trial of a alleged cop killer. I thought it'd be good because it's a short stream, but not much interest in it. But saying that, I didn't really advertise it either, so no, I can't find a bloody link for it. All I know is that state that apparently 99% resting today. I think it's 100%, but they're resting and then they're going to go through jury instructions. But I don't know if the defendant or the defense are going to put a case forward. That's what we're waiting for to hear that. And maybe that's a delay. Maybe they're discussing some stuff with the defendant this morning. I don't know. Off record. There's no real excuse. They should be live now. I mean, no, nothing. Oh, Danny boy. The pipes are calling from glen to glen. Dee, 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 dee. What's this? I got it. I think. Hold on, let me listen to it for a second. Hang on.
Appears here with Mr. Carmen, the state by Ms. Runty. The jury is seated. It's 9:11 a.m. to resume trial today. Ms.
Here you
Runty?
go.
Your Honor, the state has no further witnesses to call and no further evidence to present. We would rest our case.
Thank you. The state has rested their portion of the presentation. And because she's choosing to do that, I must ask you to go back to the jury room for a few minutes. So, thank you.
How pissed are you? Just come in, sit down, get your ass in gear. Like, you know, we're just resting. Okay, so go back. I'd be livid.
Please be seated. Mr. Carmen.
Your Honor, I make a motion for a direct verdict at this point. My argument is very simple. By the way, as to counts 1 and 2, making a direct verdict in that testimony of the state's expert witness, Sergeant Kuhn. I asked him quite clearly if it was possible that Mr. Richardson never regained control of his vehicle after he left the roadway.
Pull up your mic.
Sorry.
That's all right. Thank you. Thank you.
Never regained control of his vehicle after he took it off the roadway, that his reaction time was very slight based upon the speeds of the vehicle, the speed of his vehicle, and the distance from the point at which he left the roadway until the point that he struck Deputy Weist. I think even viewing that evidence in a light most favorable to the state, there is reasonable doubt as to whether my client intended to kill or drove his vehicle with such intentionality that the court would have to conclude that he intended to cause bodily harm or death to Deputy Weist.
Thank you. Ms. Runty.
If the court will recall, crash reconstructionist Kuhn also testified on redirect examination that while that is certainly a possibility, as he deals in possibilities with his scientific portions of his duties, that it was not his belief, based on the evidence that was in front of him, that that was what had occurred on this date at the incident scene, and that it was his belief, based on the evidence in front of him, that there were inputs put into the vehicle, steering maneuvers that had been made, and that those were on purpose. So I do believe that as to those issues, that the state has presented adequate evidence, and that their motion for a directed verdict should be denied.
Viewing the evidence and testimony in the light most favorable to the state, I believe the state has set forth sufficient facts for a trier of facts, which is the jury, to determine whether or not the state has met their burden of proof on all 4 counts. So for those reasons, Mr. Carmen, your motion for directed verdict is denied. Do you want a few moments with Mr. Richardson?
No, he and I have made this decision already.
Okay. So Mr. Richardson, you understand you have an absolute right, constitutional right to not testify. Do you understand that?
Yes, ma'am.
And that if you choose not to testify, Mr. Richardson, the jury cannot hold that against you. As you sit there, you are not guilty, Mr. Richardson. You understand that?
Yes, ma'am.
And that you understand that it is the state's burden and will remain the state's burden of beyond a reasonable doubt to prove each element of the offenses that are charged against you.
I do, Your Honor.
Do you feel that you have had sufficient time and opportunity to discuss your decision with Mr. Carmen?
Yes, ma'am.
And are you satisfied with your conversation with Mr. Carmen?
Yes, ma'am.
And his counsel?
Yes, ma'am.
And so at this time, Mr. Richardson, the court is asking if you are choosing not to testify or to testify on your own behalf, sir.
I am not testifying.
Okay, thank you. So we'll call the jurors back into the room, please. We could have the jurors, we're just trying to get them to have steps, get their steps in tonight, right? Please be seated. Mr. Carmen.
Yes, Your Honor, thank you. My client has elected not to testify, and we are not putting on any evidence of our own.
Thank you. So the defense rests.
So the defense rests.
Thank
yes.
you, sir. So ladies and gentlemen of the jury, at this time, because the attorneys and myself have to do some administrative things before I give you the case, I'm going to ask you to go back to the jury room. We're just trying to get you to have your steps get in today. So we hopefully won't be horribly long. I brought bagels hoping that would entertain you for a little bit this morning. So I'm going to ask you to go back to the jury room and let us take care of our administrative things, and then we'll have you brought back. Thank you.
I understand she has to do it this way because of process, but how annoyed are you going to be as a juror? In, out, in, out. Now wait. They're just going to go through jury instructions now.
No, that was something that I had left.
Oh, okay. All right. I thought you wanted something to write on. Be seated. So the jurors are out of the room at this time. Ms. Brunty and Mr. Carmen, let's do our jury instruction conference, please.
That'll work for me then. I've got to put mine in order now.
Ready?
Yes, ma'am.
So I have what's been numbered as People's Instruction Number 1, IPI Number 1.01. Members of the jury, the evidence and the arguments in this case. Mr. Carmen.
No objection.
So that will be given without objection. Then I have what's been numbered as People's Instruction Number 2, IPI number 1.01A. Members of the jury, the trial is about to commence, which is always kind of weird. And I did give that at the beginning.
You did.
Typically, I apologize, typically, Your Honor, I provide that as a part of the instructions, but since the judge reads that at the beginning, they typically choose not to give it.
I understand. And every place that I've done a trial in our circuit, I always get this jury instruction proposed by the state. And when we come to it, and I'm grateful to the attorneys that do this, in case we forget at the beginning, I think the state moves to withdraw.
So I'll withdraw People's Instruction 2.
Okay, so people's instruction number 2 is withdrawn. Then I have what's been numbered as people's instruction number 3, IPI number 1.01 capital B. We all have feelings, assumptions, perception, fears, stereotypes. Mr. Carmen.
No objection.
That will be given without objection. Then I have what's been numbered as people's instruction number 4, IPI number 1.02. Only you are the judges of the believability of the witnesses. I'm gonna do this one together with people's instruction number 5, which is also IPI number 1.02. The difference between 4 and 5 is that on 4, it has the single line denoted as a separate paragraph. You should judge the testimony of the defendant. People's instruction number 5 omits that sentence.
I'll withdraw People's Instruction number 4.
Okay, so people's instruction number 4 is withdrawn, and people's instruction number 5, IPI number 1.02, only you are the judges of the believability of the witnesses. Mr. Carmen.
No objection.
That will be given without objection. Then we have people's instruction number 6, IPI number 2.04. The fact that the defendant did not testify. Mr. Carmen.
No objection.
That will be given without objection. Then I have what has been marked as people's instruction number 7, IPI number 1.03. Opening statements are made. Mr. Carmen.
No objection.
That will be given without objection. And I have been numbered people's instruction number 8. Those of you who took notes, Mr. Carmen.
No objection.
Given without objection. Then I have what's been numbered as people's instruction number 9, IPI number 2.01R. The defendant is charged with the offense of murder. The defendant has pleaded not guilty. Under the law, a person charged with murder, and in parentheses it says intent to kill or do great bodily harm, may be found 1, not guilty of murder, parentheses, intent to kill or do great bodily harm, and not guilty of aggravated reckless homicide, semicolon, or 2, guilty of murder, parentheses, intent to kill or do great bodily harm, semicolon, or 3, guilty of aggravated reckless homicide. And then it goes into the defendant is charged with the offense of murder, and it goes for all of that. Mr. Carmen.
I've had some concerns about this instruction since it was tendered. The jury has not yet, well, I guess they will have heard in my closing argument, and possibly Ms. Rente's, about aggravated reckless homicide. But that will be the first they hear.
No, I know.
So.
And obviously, you know, you or she or, you know,
I suppose this is really the only way to do it.
well, and it's the IPI instruction number. I guess my question is,
So this was the one, Your Honor, that from previous conversations I had changed what was in the parentheticals to more closely reflect the statutory language as opposed to factual language.
right.
after discussion among the parties. So
Right.
that change has been reflected here,
Right.
as you read.
Okay. So, Mr. Carmen, as to People's Instruction number 9, IPI number 2.01,
No objection.
so that will be given without objection. There's People's Instruction number 10, IPI number 28.01. The state has also alleged that when the defendant committed the offense of murder, parenthesis, intent to kill or do great bodily harm, and murder, parenthesis, strong probability of death or great bodily harm, the defendant murdered a peace officer when the officer was killed in the course of performing his official duties, and the defendant knew or should have known that the murdered individual was a peace officer. The defendant is denied this allegation. Mr. Carmen.
Just a grammatical change. I think
Okay.
these allegations, because there's two. One is that he was a peace officer in the course of performing his official duties, and that he should have known that knew or should have known that he was a peace officer. So I think that's plural.
Where?
The last line has denied these allegations.
Oh. All right, so, we'll annotate that. Well, if we change the defendant has denied these allegations with an S, once that's changed, any objection?
No.
So we'll get it edited and then changed and review it. It's been marked as People's Instruction number 11, IPI number 2.02. The charges against the defendant in this case are contained in, Mr. Carmen,
No objection.
be given without objection. And People's Instruction number 12, IPI number 2.03. The defendant is presumed to be innocent of the charges against him. Mr. Carmen,
No objection.
that will be given. And I have People's Instruction number 13, IPI number 28.02. The state has alleged that the murdered individual was a peace officer killed in the course of performing his official duties. The defendant is presumed to be innocent of this allegation. The presumption remains with the defendant throughout every stage of the trial and during your deliberation on the verdict, and is not overcome unless from all the evidence in this case, you are convinced beyond a reasonable doubt that the allegation is proven. The state has the burden of proving the allegation beyond a reasonable doubt, and this burden remains on the state throughout the case. The defendant is not required to disprove the allegation. Mr. Carmen.
I believe this is incomplete in that it discusses only that he was a peace officer killed in the course of performing his official duties. It does not make any reference to the fact that the state has the burden of proving beyond a reasonable doubt that my client knew or should have known that he was a peace officer.
I can double check the IPI, and certainly if that language is in the IPI, I would not object to adding it. If it's not, then I would.
Hi, Wendy. Sorry, I was just everywhere there. This is just we're on the last legs of this trial. It was a 3-day trial. This is the third day. They're just going through jury instructions. But nice to see you. Josie's in and out. But not many people here.
So, and
I don't think they're here, but
I
they're
have
all
a portion of
going to be pretty good
28.01,
trial.
the IPI. And the state has also alleged
I was just streaming this in case
defendant
people are
murdered a
bored.
peace
Oh, here she is.
officer when
Josie
the
is here.
police officer was killed in the course of performing his official duties. And the defendant knew or should have known that the murdered individual was a police officer.
I have that instruction included later, Your Honor, and I have 28.02 pulled up from the,
Okay, I'm reading 28.01.
I understand, and I have 28.01 included later in the instructions packet
Okay,
with that language
Okay.
that he knew or should have known.
and so 28.02,
Does not read that way.
Mr. Carmen, you want to go look at that?
No, I understand exactly what she's saying, but in the sequence of events, of instructions, as you give them, you're going to be telling them first this is what they have to find, prove my client guilty beyond reasonable doubt. And then they're going to get an instruction that says, oh no, they also have to throw this one in there too. That seems confusing to me.
As I said yesterday, I understand what Mr. Carmen is arguing. Unless there is not an IPI instruction that specifically addresses the matter at hand, or it's misstating the law, I don't like creating an instruction. So tell me what 28.02 says, please.
On the illinoiscourts.gov website that contains the most recent updates for the Illinois pattern instructions, 28.02, enhancement / extended term factors, presumption of innocence, -- reasonable doubt, -- burden of proof reads. Okay, there's all kinds of brackets in here. How much? The state has alleged that insert the appropriate enhancement or extended term factors. The defendant is presumed to be innocent of these allegations. This presumption remains with the defendant throughout every stage of the trial and during your deliberation on the verdict, and is not overcome unless from all the evidence in this case, you are convinced beyond a reasonable doubt that the allegations are proven. The state has the burden of proving the allegations beyond a reasonable doubt, and this burden remains on the state throughout the case. A defendant is not required to disprove these allegations. And there's committee notes under it that say give instruction 28.01, give 28.03.
Understand. And I think this, Mr. Carmen, 28.02, because I'm reading it, is essentially stating that Mr. Richardson is presumed innocent of the allegations, and that remains with him. I don't know if that's the proposition instruction, because I'm reading it right now, and I can see the committee notes. Give instruction 28.01, give instruction 28.03 and 28.04, and in perusing the other proposed instructions, those are included in there, because there's got it. The 28.03 is issues and enhancement or extended term factors to sustain the charge, and I see that later. So I don't think that it's confusing. I think this is a general statement that Mr. Richardson is presumed innocent of those allegations, and that it's the state's burden. So if you're objecting to people's instruction number 13, we'll note that for the record, and I'm going to give it with objection. Then we have what's been numbered as People's Instruction Number 14, IPI Number 3.02, Circumstantial Evidence. Mr. Carmen
No objection.
will be given. Then I have People's Instruction Number 15, IPI Number 4.08, the term peace officer means. Mr. Carmen,
No objection.
given without objection. I have People's Instruction Number 16, IPI Number 5.01, a person acts recklessly when he, Mr. Carmen.
Yes, that's acceptable.
I'm sorry?
It's acceptable.
Oh, I'm sorry. It will be given without objection. My ears are stopped up, so
And my voice got caught.
sorry. People's Instruction Number 17, IPI Number 5.01, capital B. A person acts knowingly with regard to the nature or attendant circumstances of his conduct when, Mr. Carmen.
1 second, please.
Sure.
No objection.
That will be given without objection. People's Instruction Number 18, IPI Number 7.01, capital B. A person commits the offense of murder when, Mr. Carmen.
No objection.
That will be given. People's Instruction Number 19, IPI Number 7.01, capital B. Is the same instruction as People's Instruction Number 18.
It's not the same, it's slightly different. No objection.
It's slightly different because of the parenthetical.
Correct.
Okay. Any objection, Mr.
No,
Carmen?
no
That will be given. People's Instruction Number 20, IPI Number 7.02, capital B. To sustain the charge of murder, the state must prove the following propositions. First proposition, that the defendant performed the acts which caused the death of Nicholas Weist. And second proposition, that when the defendant did so, number one, he intended to kill or do great bodily harm to Nicholas Weist, or number two, he knew that his acts created a strong probability of death or great bodily harm to Nicholas Weist. If you find from your consideration of all the evidence, and it goes forth from there. Mr. Carmen.
No objection.
That will be given without objection. At People's Instruction Number 21, IPI Number 28.03, to sustain the allegation made in connection with the offense of murder, the state must prove the following propositions. Proposition, that when the defendant committed the offense of murder, the defendant murdered a peace officer when the peace officer was killed in the course of performing his official duties, and that the defendant knew or should have known that the murdered individual was a peace officer. Mr. Carmen.
I know these are IPI, Your Honor, but I would still say the following propositions, because they're two, because
I
they're
agree.
separate propositions.
I agree. So we need an S following the word proposition.
That's it.
And then once it's edited, we'll review it and Mr. Carmen can make his objection or not, no objection.
No objection other than that.
Okay. And we have People's Instruction Number 22, IPI Number 7.09, capital A. A person commits the offense of aggravated reckless homicide when he unintentionally causes the death of a peace officer during the course of his official duties as a peace officer by driving a motor vehicle recklessly and in a manner likely to cause death or great bodily harm. Mr. Carmen.
No objection.
So that will be given without objection. People's Instruction Number 23, IPI Number 7.10, capital A, to sustain the charge of aggravated reckless homicide, the state must prove the following propositions. First proposition, that the defendant caused the death of a peace officer during the performance of his official duties as a peace officer by driving a motor vehicle. And second proposition, that the defendant drove a motor vehicle recklessly And third proposition, that the defendant drove a motor vehicle in a manner likely to cause death or great bodily harm. If you find from your consideration of all the evidence, and it continues from there, Mr. Carmen.
No objection.
That will be given without objection. Then I have People's Instruction number 24, it's 2 pages, IPI number 26.01R. When you retire to the jury room, Mr. Carmen,
No objection.
that will be given without objection. I have People's Instruction number 25, IPI number 28.04. The state has also alleged that the defendant murdered a peace officer, and the peace officer was killed in the course of performing his official duties, and the defendant knew or reasonable should have known that the murdered individual was a peace officer. You find the defendant is not guilty of the offense of murder, you should not consider the state's additional allegation regarding the offense of murder. If you find the defendant is guilty of murder, you should then go on with your deliberation to decide whether the state has proved beyond a reasonable doubt the allegation that the murdered individual was a peace officer killed in the course of performing his official duties. Accordingly, you will be provided with 2 verdict forms. Quote, we, the jury, find the allegation that the murdered individual was a peace officer killed in the course of performing his official duties was not proven. And, quote, we, the jury, find the allegation that the murdered individual was a peace officer killed in the course of performing his official duties was proven, excuse me. From these 2 verdict forms, you should select the one verdict form that reflects your verdict and sign as I have stated. I don't see, because at the top, Ms. Runty, you have, and the defendant knew or reasonably should have known that the murdered individual was a peace officer, but that is not included in the
verdict
anywhere
form,
else.
in the verdict form description.
Well, in the verdict forms, or the state has proved beyond a reasonable doubt that the allegation that the murdered individual was a peace officer killed in the course of performing his official duties, and to reflect the same language in the first paragraph.
Well, I'm struggling with something else, Your Honor. In the first, and again, it really doesn't affect what I do, but I don't want the jury to get confused. If you find the defendant guilty of murder, you should go on with the, well, excuse me. If they find the defendant not guilty of murder, they still are going to be asked to decide under the aggravated reckless homicide statute if defendant was a peace officer killed in the course of performing his duties.
Yeah, but that's in that proposition.
That's not, that's in the aggravated reckless, in the statute, the aggravation,
Oh, regarding, I see.
Do you see?
I see the last clause of the sentence covers that.
Yes.
That's fine.
Okay.
Okay, so I flipped over to 28.04 on the Illinois Courts.gov website. When it gets to the end, after all of the choices.
Sure.
Okay. That is the paragraph that it gives. If you find the defendant not guilty of the offense of blank, you should not consider the state's additional allegations regarding the offense of blank. If you find that the defendant is guilty of blank, you should then go on with your deliberation to decide whether the state has proved beyond a reasonable doubt the allegation that, and then it says insert the appropriate enhancement / extended term factors.
Right. And under, if you look at go back to 28.01, it has that the murdered individual was a peace officer killed in the course of performing his official duties, and that the defendant knew or should have known. So if we want to call it, if you want to call it modified, but I want the language in this paragraph and then the verdict forms to match the language in the first paragraph of your people's instruction number 25.
This is, what instruction?
So
I had to read.
people's instruction number 25,
Right.
all right? So the third
All right,
paragraph,
I was in a world of my own there.
it should read, if you find the
How are you?
defendant is
Hope
guilty
you're
of
well.
murder, you should then go on with your deliberation
Hey,
to
John.
decide whether the state has proved beyond a reasonable doubt the allegations that the murdered individual was a peace officer killed in the course of performing his official duties, and that the defendant knew or should have known that the murdered individual was a peace officer.
From instruction 10.
Yes. And really, it's, if you look up at your first paragraph in people's instruction number 25, it has that same language. Your very first paragraph on this same instruction. The murdered individual was a peace officer killed in the course of performing his official duties, and the defendant knew or reasonably should have known that the murdered individual was a peace officer.
Okay, I'll drop that language down.
Well, and then the next paragraph, accordingly, you will be provided with 2 verdict forms. Quote, we the jury find the allegations that the murdered individual was a peace officer killed in the course of performing his official duties was not proven. So an S in there. And we the jury find the allegations that the murdered individual was a peace officer killed in the course of performing his official duties was proven, and the defendant knew or reasonably should have known that the murdered individual was a peace officer. So you need to add that to
The last part of
the last part of paragraph 4.
Okay.
Mr. Carmen, any?
With the court's corrections, I wouldn't have any objections.
And then we're on to people's instruction number 26, which is IPI number 26.02. We, the jury, find the defendant, Daylon Richardson, not guilty of the offense of murder, and in parentheses, intent to kill or do great bodily harm, and not guilty of the offense of aggravated reckless homicide. Mr. Carmen?
No objection.
Given without objection. And then I have people's instruction number 27, IPI number 26.05. We, the jury, find the defendant, Daylon Richardson, guilty of the offense of murder, parentheses, intent to kill or do great bodily harm.
No objection.
That will be given without objection. Then I have people's instruction number 28. We, the jury, find the defendant, Daylon Richardson, guilty of the offense of aggravated reckless homicide. Mr. Carmen?
No objection.
Will be given without objection. Then I have people's instruction number 29, IPI number 26.02. We, the jury, find the defendant, Daylon Richardson, not guilty of the offense of murder, parentheses, strong probability of death or great bodily harm, and not guilty of the offense of aggravated reckless homicide. Mr. Carmen?
No objection. No objections.
That will be given without objection. Then I have people's instruction number 30, IPI number 26.05. We, the jury, find the defendant, Daylon Richardson, guilty of the offense of murder, parentheses, strong probability of death or great bodily harm. Mr. Carmen?
No objection.
That will be given without objection. Then I have people's instruction number 31. We, the jury, find the defendant, Daylon Richardson, guilty of the offense of aggravated reckless homicide. Mr. Carmen?
No objection.
That will be given. Then I have people's instruction number 32. We, the jury, find the allegation that the murdered individual was a peace officer killed in the course of performing his official duties was not proven. Mr. Carmen?
Same problem as before, Judge, there needs to be reference to.
No, this is that,
Was a peace officer killed in the course of performing was not proven, that's, if there's no separate instruction form, no.
there is, the next one is,
I don't have it.
we, the jury, find the allegation that the murdered individual was a peace officer killed in the course of performing his official duties was proven. I want her to add on that instruction that the allegation that the murdered individual was a peace officer killed in the course of performing his official duties and that the defendant should have known.
That's fine.
So with number 32, do you want that language added as well?
I do.
Okay, so people's instruction number 32, please add, in the course of performing his official duties and that the defendant knew or reasonably should have known that the murdered individual was a peace officer was not proven in the same for people's instruction number 33. Does all that make sense, Ms. Renton? We're just matching the language.
Yes, and so I'm going to ask if you want to go back to the other one, because we did not add in the other one
I
that.
agree. We didn't add it in there.
If you put it one place, you have to put it the other
I
place.
agree.
And while I would say that I
So
don't
tell
think
me,
we should
tell
do
me
it
where.
On,
John, are you still Jonathan? You're still here. Doreen, are you still here?
Number 25.
Rosie, are you still here?
So
Who's here?
yes,
if that's what you're doing, which
Oh God.
I would make, I would
Just
still
do
make
my
the
head in.
argument that if it's not proven, it's not proven. It doesn't matter what part of it is not proven.
I understand, but I think for consistency, and for, so there's no confusion for the record or for the jurors, let's just have the language match.
Yeah, I'm just bored. Sorry, I'm just bored to see if anyone's in chat.
I don't necessarily disagree with you, but,
We've got Doreen here.
so.
I'm not sure if she's gone, but we had the Doreen.
So do you want me to say, okay, so in there, find the allegations that
Hey,
the murdered individual. was
Doreen, do you like them out in the
in the
hat?
course of performing his official duties and that the defendant knew or
Great.
reasonably should have
Hey,
known
I know you
That
work
the
in this
murdered
thing.
individual
was
Look
a
at the
peace
screen.
officer was not.
Was not proven.
You don't
Look
need to
at
make
that.
that clause negative, just leave the negative at the end.
Little boy.
Okay. I
Ah,
just,
one of one. You can tell I'm bored, guys. Why do we stream this trial? All right, everyone go back to work. Go back to work. And listen, it's fine. I'm just bored. Into our 30s. Oh, Jesus, Jonathan.
And we'll give you a few minutes to get those changes and copies.
Let's take a look later on.
okay, do you want to, do we have any defense instructions or you want to do these separately?
No, because of
That's-
the
you're
way
fine.
you tendered it, I'm fine with it.
So you have no,
I'm not going to tender
Yeah.
plain old reckless
okay,
homicide instruction because the sentencing range is the same.
which makes sense. Okay, so you want a few minutes to get those, because by my count, my turned correction sheets, there's 5 pages.
Five.
Okay. All right, so we'll, let's do about a 10-minute recess to give her a chance to get that stuff done. I don't expect her to be running all over the buildings for, so. We'll be in recess for about 10 minutes.
Okay, recess for 10 minutes. Let's pause it for a second. So anyway, welcome, Doreen. Thank you for being here. I know you found us through Turtle Boy. Oh, hang on, let me go big screen. We picked this case up 3 days ago. This is the 3rd day. The only person streaming it is the cop killer one, but I've not listened to any of it because we've got another trial started in an hour's time on another stream that we're doing from Seattle, quadruple murder trial. So everyone's in that one. No one's watching this really. Tomorrow, I'm doing a stream for everybody based on Karen Reid. I just put it on Twitter. I did put a link in the chat, I think. Yes, I have. So make sure you're there tomorrow, 10 o'clock Eastern. There's nothing new I'm going to speak about. But there's so many people new to the trial, to the case. So I'm going to speak about that tomorrow. It's a safe to because it only go boom if under pressure. I have no idea what you're on about. But I sort of guess, but I don't know. So anyway, people, I'm not used to getting chat so quiet. That's why I pick on people then. Anyway, you guys are busy. You're all working hard, so ignore me, mute me for 10 minutes. But Jonathan, why do we do this trial again? I don't mind doing it. It's just like I've not watched any of this trial, so you know more than me about Daylon. Lord, Billy Joel. Well, I am blaming him because Josie, he was in my ear going, "We need a new trial. We need a new trial. We need it." So I went. I was like, "I'm not just going to do the same old trials as everyone else." I found this trial, but then no one's watching it, like not properly. Do you know what I mean? So I just don't blame anybody, but I've unplugged something. Plug. Fuck. I've unplugged now. Bear with me. I think we're fine. We're fine. So yeah, I don't think we're going to do another trial, two trials again, Jonathan. I think it's too hard because when you've got so many people watching the Krieger one, I know people are frustrated with the Krieger one, but you can't do two because you can't listen to two. Do you know what I mean? And you're actually, Jonathan, you're in the Krieger one in chat, so I don't know. We'll think about what to do next week. I completely listen. No, you're not. I have been. Have you really? Because you're always in the Krieger chat, so I wasn't sure if you were listening properly to this or not. Anyway, Doreen, don't be scared of this chat. The chat is normally bouncing, not bouncing, but um, what a first impression. Coming into a trial that we don't give a fuck about. Oh, yeah, that's fair. That's fair. That's fair. That's fair. I mean, yeah, no one chats in here, so let's have a look. Let's have a look. There's that. So yeah, I don't know what else we talking about. What else is going on? Oh, I did say, I'm not sure if people listening, but tomorrow starting my 11,000 steps a day. How much is 11,000 steps for prostate cancer? Let's have a look. I've not really done much uh, research into this. Oh no. Steps in miles. 5.5 miles, just over 5.5 miles. How much is in kilometers then? I don't know. All he does miles, so that's fine. So yeah, the whole of March, if you don't know, whole of March, I'm doing 11,000 steps per day for the whole of March for raising awareness and money for prostate cancer. I'm 20 pounds short of my target, but my parents they haven't donated yet. They will be donating. So essentially, I've reached my target. The target was $300, and I've basically reached it. So I'm happy with that. Happy with that. Happy with that. Can you believe? Can you believe it if this was your first time coming to this channel and we got this? You won't come back, will you? Put this in then. What do they call that? I think so as well. From what you've told me, it's just gonna be they're gonna be out there for 10 minutes, eat the food, and come back in and be like, yeah, guilty. We still got closings to go though, do you know what I mean? So we'll see. The fact that defense didn't put any kind of representation for defendants. I feel sorry about it. I think the judge is quite good. Yesterday, the judge was like, "Oh, do you want to talk to your client's defense attorney about X, Y, and Z?" And he was like, "Oh yeah, okay, I'll go to the chambers." And she was like, "Yeah, how about you take the parents in as well? I think it'd be good for you as parents to understand what's going on as well." That was nice of her, I thought. I felt so sorry for his parents though. Can you imagine his son is basically going to be going to prison for life, and you're there in court? Oh, horrible. Okay, eye for an eye, tooth for a tooth. I got you. What's this thing though? What's the eagle thing? What's that stand for? What's the eagle thing stand for? No parent wants this out of their kid. Makes them. I don't even think about making it look terrible. I bet you either one of them would just swap places with him. No one wants to see their son, you know, in that position. I don't think it even matters about looking terrible. I just think they don't think they want to. Your son's going to jail for the rest of his life potentially. Freedom. It's a national animal. Okay, the eagle. Oh yeah, I didn't know what it was. Saw a bald eagle 20 feet away. I can imagine bald eagle. They're huge. Excuse me. He was eating a baby. Oh my god! Do you have to say that now? Did you even have to say that? Anyway, those that are lurking or they're just deciding some stuff, then it's gonna be closing arguments. And then yeah. But if you're just here for because you're bored, then come and join us for the Krieger one. I'll post a link for the Krieger trial in a little bit once we go over to that one. Especially if you don't really listen to, have seen this. Because there will be closing arguments, but as Jonathan said, I think it's pretty cut and dry, this one. Whoa, 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 whoa. Whoa, 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 whoa. It was by my grandpa's farm. There's only one tagged eagle in that area, so odds are it's a one tagged and tracked, caught in some bad hot pans. Oh, oh my days, I can't believe it. Come on, Irene. Ba-da-ba-ba. Did I hear you ask for a special spring offer? No, you didn't. You didn't, Liz. How long do you think they could be out for this one, Jonathan? Deliberating, I mean. How long are they going to have for closings? Ugh. You see, you just. Someone asked me what this chat's about. Just show him Jonathan. If you can stand what he's on about, I ain't got a clue what you're on about. They take less than Kariga. Yeah, I agree. I agree with you, John. Agree, agree, agree. I agree. I don't know what to say. I mean, I'm just. There's not much to say about this in this trial, and everyone's working. Jonathan, you and me are the only ones not working right now. Well, technically we are, but we're not. I can't even say much about this trial because I was listening more to the Kariga trial. They put police on the stand, and after that moved on. So the evidence the state has is very, very good. And hello, Tracy. How are you doing, my darling? Hope you're well. Long time no see. How is things with you? You come in, as I say, you come to a trial that Jonathan's an expert in it, but I've not. Hopefully, you come and join us for the Krieger trial if you know anything about it, because it's getting spicy. The spice, the spice is coming out for Krieger. Oh my god, I can't believe it. Tracy Saunders is in chat. Oh my god, can't believe it. Ba-da-ba-ba-da-ba-ba-ba-ba. I would love to hear the closing arguments, but all good. Yeah, still recovering from the Super Bowl. Vegas was a hot mess for an entire week. I could imagine. I imagine it would be yes. It would be yes. Vegas. No, I knew we. Vegas, 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 Vegas. But you're Henderson though, aren't you? So you're about half hour away from the, the strip or whatever. I can only imagine. I can only imagine. Did Vegas ever legalize mushrooms, edibles? I know they did cannabis. Question for you, Tracy, from Jonathan. You are my fire, my only desire, and you do. I want it my that away. Tell me why, ba-da-ba-ba-dee-dee-dee. Tell me why. Do-do-do-do-do-do. Here to stay. I want it that away. Do-do-do. Henderson. Yeah, well, so you're right next to the practice field and stuff, and Raiders Way. Is it Raiders Way that is in Henderson, or is that the one in in Vegas because no one of there's a Raiders Way. I believe that is in Henderson. One Raiders Way or something like that. And the practice facility is opposite the private airport in Henderson. Sky Henderson something, I believe it is. Or Henderson Sky Airport. And it's opposite the practice facility for the Las Vegas Raiders. Oh my God, I can't believe it. Yes, correct. Yes, you see, I know my shizzle dizzle. I know my shizzle dizzle. Wow, you've been here. I've been to Vegas a few times, yeah, but I've never been to Henderson. I haven't been there. I just anything to do with NFL, fairly clued up on. So I knew because I watched the documentary of them building the new stadium and the practice facility and stuff like that. So I did some research on it ages ago, years ago. So no, but I've been to Vegas a few times, but never to Henderson. I love Vegas. I enjoy it. But I think you would enjoy it as a tourist. Maybe not so much as someone living there. Ooh, shake, 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 shake. The emblem is shaking, shake, 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 shake. Either this cameraman's been on the booze last night, or we're back, and we're back. Let's go. Let's go. Well, I mean, so enjoy yourself, son. I think he's gonna be cuffed up before long. It is. Yeah, it is. Even everything. Do you know what I mean? So anyway, hello, Frida. It's not great, is it? I'll be honest, it's not great. But I'll be honest with you, it's been worse. I've seen courts much worse than this. Wow, you've been here. Yeah, I've been there. Oh, been Vegas a few times. I used to play the World Series of Poker out there, or do the circuit out there. I haven't been for oh quite a bit of time now, actually. I don't remember when the last time was. Probably good 8 years ago now. They have trash audio, yeah. If people are struggling with the audio, then you can there's an app called Volume Master. Jesus Christ. I'll turn it off until the judge comes in. It's called Volume Master for Microsoft for laptops and stuff like that. I'm not sure if you can get it for other stuff, but it's incredible. Incredible. I've got it 100% now because it sounds okay, but if you do want a booster for your sound, go search for Volume Master. Okay, hang on, I can just get it for you here. This is a good extension to have. Oh my God, I can't believe it. Dee-dee-dee-dee-dee-dee-dee-dee. In about 45 minutes or so, we have the Carriega trial from Kitsap County, Wisconsin. No, Seattle, Washington, Seattle. Oh my God, Becky, look at her butt. I didn't see her butt. True. There we are. Oh. Mm. Okay, the state they're out. Okay, so they're back. So the judge will be no long behind now. So which is a good thing. Ah, fuck. Here we go. Come on, Judge. Let's get the show on the road.
Yeah, we're muted because, I can't hear. I want everybody to be in the same boat.
Jesus, number. Come on.
So there's yours and the plain copy for the jury. I believe they're in backwards order, Your Honor. I apologize for those.
But that's okay. I'm capable, I think.
The one instruction dropped to 2 pages because it wouldn't leave room for a numbering block at the bottom of it.
I'm going to go through them backwards. So let's go back on the record in 22 CF 134 for our jury conference. So, Mr. Carmen, I want to start with the verdict forms. And so people's instruction number 32, IPI number 28.05, we, the jury, find that the allegation that the murdered individual was a peace officer killed in the course of performing his official duties, and that the defendant knew or reasonably should have known that the murdered individual was a peace officer was not proven. Any objection to be edited?
No.
So that will be given without objection. And then I have People's Instruction Number 33, IPI number 28.06. We, the jury, find the allegation that the murdered individual was a peace officer killed in the course of performing his official duties, and that the defendant knew or reasonably should have known that the murdered individual was a peace officer was proven. Any objection?
Now I'm going to go back and rescind my statement that there was no objection. With the same problem on plurals versus singulars. We find that the allegations, because there are two different allegations.
Ms. Runty, can you add
Whip something else up.
an S at the end of allegation? So don't run away. Let's move on to the People's Instruction Number 25.
And that's the one that dropped to 2 pages, Your Honor, with the added language.
Okay. So in People's Instruction Number 25, specifically in paragraph 3, the state added the S at the end of allegations. Would you agree, Mr. Carmen?
I do.
And then in paragraph 4, we find that you missed the S on the allegations again in that paragraph, Ms. Runty, in both spots. We, the jury, find the allegations in both spots.
So then you want it in the last paragraph on the second page as well. Your agreement on the verdict as to the allegations should
Yes.
also be unanimous.
And then I have what would be People's Instruction Number 21, IPI number 28.03. The word proposition, she added the S to that, Mr.
I see
Carpenter.
that.
So any objection to that?
No.
So that with the edit will be given without objection. And then I have People's Instruction number 10, IPI number 28.01. She changed the second line to read, the defendant has denied these allegations.
Correct.
Any objection?
No.
So as edited, it will be given. So Ms. Runke, trying to have you get your steps in as well. So I don't know if you want your office to, is your office able to add the S's and bring those down, or do you want to go up yourself?
I'll need to go over myself.
Understand.
They're documents I drafted, so they're on my
Understand.
computer. Did you want to ask her about closings or?
What you gotta do?
What?
Housekeeping stuff.
Oh, okay. I'm like I said, my ears are stopped up, so you have to speak up a little.
Be yelling.
Guess my hearing's matching my age, I don't know.
It's okay. They're going to do some changes to the jury instructions, and then they will be read out. They will get closings, and then we'll be deliberations. And Jonathan believes that we'll be done in a few hours. No pressure, Jonathan. I will be off screen in a bit once the Craig trial comes up. Actually, I need to set it up now. I'm going to set it up before I forget. Okay, okay. What am I saying? This Kids Up trial. Dee, 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 dee. Dee, 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 dee. Okay, there's that. Ba, 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 ba. Ooh, wrong one. So I'll just set the zoom I am for Krieger trial. Bim bam. Wee beep 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 beep. I repeat, I bet like man. Gofyn rwyf am galon hapus, calon o, nes calon la, calon on, am samfaioni, tegach yw na'r lili dlo, dim ond calon arall ganu. Canu'r dydd a chan yn i'r nos. Beth y brothion ein dymuniad di 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 da 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 da. Okay. Sarah P's been there already. Well done, Sarah P. Share screen. Da, da, da. Da, 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 da. Okay. So Kitsap is ready to go in 15 minutes. So yeah. Let me just open it, view on YouTube. StreamYard, YouTube. You're the one that I want. You are the one I want. Ooh, 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 hi. The one I want. You are the one I want. Ooh, ooh, ooh. The one I need. Ooh. Mm. Oh. Okay, got that. Got that, yeah, baby, we got that. My desire, you're on fire. We just copy paste this, and then we got it. So if anyone does want to join us for the Craig trial, the link is in the box here. It's not gone live yet. We'll be going live in about 15 minutes. just in trials, quadruple murder trial. We're on day 44, I believe. So, you know, you've missed most of it, but in actual fact, now we become interested. Oh, we just like the stream Krieger. Dee, 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 dee. Oh, the judge went off. I didn't see the judge go off. She's back. This was a typo. That's all. I feel as bored as that defense attorney feels. Here we go. Here we go. Here we go. Here we go. Oh, yeah. Come on, let's get on with it. Come on, Eileen. Let's go, people.
So Mr. Carmen would be numbered as People's Instruction number 25, the one that has been moved on to 2 pages now. Paragraph 3 contains the S after allegations. Would you agree?
Yes.
And in paragraph 4, Ms. Runte has added the S to allegations as well as, and that the defendant knew or reasonably should have known in both spots. Would you agree?
Yes, it would.
So with regards to People's Instruction number 25, any objection, Mr. Carmen?
No.
So that will be given. And then I have and on the second page of that jury instruction number 25, she added the S to allegations.
Yes.
Okay. And then she has tendered bear with me. People's Instruction number 32, which is She added the S to allegations, and she added the language of knew or reasonably should have known. Would you agree, Mr. Carmen?
I would.
And any objection as edited?
No.
So that will be given. And then I have what will be marked as People's Instruction number 33, IPI number 28.6.06, excuse me. And Ms. Runte has added the S to allegations as well as the language of knew or reasonably should have known. Would you agree, Mr. Carmen?
I would, without objection.
And that will be given without objection. Okay. The party is ready to proceed. Bring the jurors back, do closing arguments.
That's right.
Please be seated. Back on the record in 22 CF 134, all parties are present. The jurors are reseated. It is 10:39 a.m. Thank you all for your patience. Ladies and gentlemen of the jury, you have heard all of the evidence in this case, but the trial has not ended. At this time, the attorneys have the opportunity of making final arguments. First the state, then the defense, then the state will have a chance to respond to the defense's argument. What the attorneys say during the arguments is not evidence and should not be considered by you as evidence. After you have heard the arguments, I will instruct you on the law, and then you will retire to your jury room to consider your verdicts. Ms. Runte, is the state ready to proceed?
We are.
Mr. Carmen, is defense ready to proceed?
We are.
Ms. Runte.
May it please the court. Mr. Ladies and gentlemen, thank you for your time and your attention on this case. When you imagined what your possible jury service might look like, I'm not sure this was on your radar. I want to take some time to go through a few of the jury instructions with you. The judge will read you these instructions along with others in a few minutes, and you will get a printed copy to take to the jury room with you. There are jury instructions about the charges and about what I need to prove to you. To sustain the charge of murder, the state must prove the following propositions. First proposition, that the defendant performed the acts which caused the death of Nicholas Weist. And second proposition, that when the defendant did so, he intended to kill or do great bodily harm to Nicholas Weist, or he knew that his acts created a strong probability of death or great bodily harm to Nicholas Weist. To sustain the allegations made in connection with the offense of murder, the state must also prove the following proposition: that when the defendant committed the offense of murder, the defendant murdered a peace officer when the peace officer was killed in the course of performing his official duties, and that the defendant knew or should have known that the murdered individual was a peace officer. Please keep in your mind that the burden of proof is beyond a reasonable doubt. Let's look back through the evidence and the testimony and how it shows you that Daylon Richardson is guilty of murder. We heard first from Officer Jared Tapscott with the Galesburg Police Department. He was the lead police vehicle in the pursuit from Galesburg, and you had an opportunity to view a portion of his squad video and his body camera video. From that, we learned that the pursuit from Galesburg to the intersection of Route 150 and 150th Avenue in Henry County took approximately 12 minutes due to the high rate of speed which the vehicles were traveling. We also know that Officer Tapscott had his lights and sirens on the whole time and was doing his best to keep the fleeing Ford in his sights. We heard Officer Tapscott relay to dispatch that he saw a weapon displayed from the vehicle, and later that shots had been fired out the Ford's back window. We also heard from Lieutenant Carl Kramer from the Knox County Sheriff's Office. He was the supervisor on duty on the morning of April 29th of 2022. Knox County deputies have take-home squad cars, and Nick was driving a squad car home after his shift on that day. We learned that their practice is to sign off just prior to getting out of their squad car. A practice put in place, no doubt, so that the general motoring public who saw a squad car would know that the person could be counted on for help. The general duties of police officers include responding to calls, making arrests, and assisting other agencies. On the Knox County radio calls, we heard deputies indicating where they were in relation to the pursuit, indicating that they wouldn't be there in time to intercept. And then we hear Deputy Weist telling the dispatch that he'd be near the county line. He asks whether Galesburg is requesting the use of the spike strip and whether it is authorized. We heard on the radio and we heard from Lieutenant Kramer that he authorized that spike strip deployment. We know what happened next. Deputy Weist threw out the spike strip, and the Ford, which had been traveling in the northbound lane, diverted to the right to avoid the spikes, driving into the gravel and the grass. We also know that, based on the tire markings of the scene, the Ford turned back onto the roadway and finally made another turn to the right, bringing it in contact with Deputy Weist and the corner of the spike strip. The photos and the diagrams from the scene show us that the Ford traveled into the west ditch, overturning and eventually coming to rest upright. And Deputy Weist was projected 127 feet. Ladies and gentlemen, that's more than 40 yards. Landing in the west ditch, where he was later pronounced deceased as a result of the injuries that he sustained from being struck by the fleeing defendant. A defendant who was so intent on getting away from the police that day that even after his vehicle wrecked, he fled on foot until officers chased him down in the field. The testimony and the evidence that you have in front of you shows that Daylon Richardson performed the acts that caused the death of Deputy Weist. They show you that any reasonable person would have known Deputy Weist to be a police officer performing his official duties. And they show you that the defendant's actions were all choices, reflecting that it was his intent to get away from the police at any cost that day. and I ask that you find him guilty of murder.
Thank you, Ms. Runte. Mr. Carmen.
Thank you, Your Honor, and please support. Elected official gets to do, and I'm particularly impressed with the amount of attention paid to the various forms of evidence that you've received in this case. You've had videos, you've had pictures, you've had something called orthomosaic photographs, something I never heard of until this. So you've had a lot to digest in a short period of time. But I want to go over a couple of things about your deliberations before I start addressing the evidence as Ms. Runte presented. First thing I want to go over is, what does it mean for the state to prove something beyond a reasonable doubt? As I told you back on Tuesday, I can't tell you what that means. Judge Cowledge can't tell you what it means. You have to decide what it means. But I do get to give you a hint. And the hint that I give you is this. If in assessing a proposition, right or wrong proposition, it doesn't come to you immediately what the conclusion is, that sounds like a reasonable doubt to me. Let's talk about something else that's very difficult to talk about, but it's part of this case because there's no avoiding it. And that is the judge's instruction to you that neither sympathy, bias, nor prejudice, whether you acknowledge it openly or it's implicit within you, should be part of your decision. Now, it's hard not to have sympathy. You would be less than human if you didn't have sympathy for the enormous loss suffered by not just his family, but by the community at large as it relates to Nick Weist. It's not easy being a police officer. And when a police officer gets killed, people get upset. And the people that you've seen every day, the folks on this side of the aisle, are good people, and they care. And they have sympathy, they have bias, and their feelings have been damaged irreparably. But none of that can figure into your deliberations, into your verdict. The judge will tell you that their sympathy, bias, and those people and things should enter into your deliberations. You should make this decision based on the evidence. And Ms. Runte gave what I would consider a fine summary of her version of the evidence, but much as has occurred throughout this case, a lot of the evidence didn't quite come in until I brought it. And that is, there's two things. Number one, Officer Capscott. I asked Officer Capscott, was your vision, what you saw that day as you were pursuing Mr. Richardson, was that better than the photo quality or the video quality that we saw? He said, yes. And I said, did you see Daylon Richardson leave the roadway when Deputy Weist appeared? Yeah, I saw it. But oddly, you didn't hear anything about that in his presentation, his testimony, his presentation. He never heard back. And the one thing, the big thing that you didn't hear until I brought it out was how far it was and what time element was involved. From the time that Daylon Richardson made the decision, first the visual, sees the police officer, or sees the police car. We don't see the police officer right away because he's back behind his vehicle, opening up the stop sticks. Sees the car, says, oh my God, he's throwing stop sticks down when he sees that. How much time did he have from the time he made the first calculation in his brain that there's a guy out there who's going to put down things that are going to make my car's tires go out, and I'm not going to be able to bleed. And we know, as Ms. Runte acknowledged in her argument, there's a serious flight or fight mentality going on with Daylon Richardson. We'll get to that in a second. But one thing we know consistently throughout the videos, consistently from the testimony of Officer Capscott, consistently from the testimony of other officers, this pursuit took place in a long period of time, somewhere between 95 and 110 miles an hour. I have generously in my calculations, said, let's use the 100-mile-an-hour figure, even though we know that speeds were exceeding 100 miles an hour during this chase and for large portions of it. At 100 miles an hour, the vehicle travels 146.7 feet per second. And I asked Sergeant Coon, how far was it from the point that Mr. Richardson left the roadway to the point of impact? 160 feet. How much time, 100 miles an hour, does he have to see, react, turn, strike the officer? How much time does he have? Almost nothing. And what verifies that? Deputy Weist's squad car video. You saw it, you all saw it, it was quite shocking. Throws the sticks down, and before you can say Jack Robinson, he's hit. And he's hit hard, hit fast. So the conclusion that you should reach is, unlike the Sergeant Coon's attempt to say that the vehicle might have been slowed by dirt, or might have been slowed by the rougher terrain that he came onto. He didn't slow down that much. We're talking about less, I would say, than a second, at the best, a second and a half. What kind of intent can you put in a second and a half? Let's talk about Mr. Richardson for a second. Mr. Richardson is from Granite City, Illinois. You've heard that evidence history. It's a suburb of St. Louis. What is he doing in Galesburg, Illinois, 211 miles away at 8 o'clock in the morning? What the judges will instruct you is that you are to use your own common sense in making these determinations, and you can draw inferences from the evidence. One of the very logical inferences from this evidence is that Daylon Richardson's brain process on the morning of April 29, 2022 was not exactly calm and deliberate. Police officer sees him in possession of a firearm at a convenience store gas station, and instead of just, hey, officer, yeah, here I am, I got a gun, he runs. And he sees the alarm, he sees the flashing lights, and he doesn't stop. Pure flight, fight reaction. He's not thinking clearly. And then what happens next? He goes on a 12 to 13 minute high-speed police chase. I'm guessing that none of you have had that pleasant experience in your lives. Pretty sure you haven't. Can you imagine what your brain would be like? I mean, what's your brain like when you're late for something and you think you're in a hurry and you're driving 80 on a 70 miles an hour road? You feel like you're going pretty fast. But here's Daylon Richardson, 22 years old, in a place he may never have even been before, as far as we know. And he's racing up the back roads, which are not all flat and straight, at 95 to 110 miles an hour. What kind of judgment, what kind of intent can he form? No. This is pure reaction. And then let's talk about what happened physically when he goes into the road, comes back in the 160 feet that he has to traverse for 1.2, 1.3, 1.4 seconds. He loses control. He goes into, he's going about 100 miles an hour, and he goes into this loose gravel and grassy area. He loses control of his vehicle. He realizes he's going to crash in the upcoming farm. He realizes that. He also sees the stop sticks. He doesn't know what to do. He tries. He tries to get control of his vehicle, but he doesn't get it. Because nobody in their right mind is just trying to get away. Everything he's done from the moment he saw police officers pursuing him in downtown Galesburg until the moment he crashed his vehicle into Deputy Weist, he was out of control. He didn't have his best faculties, his best abilities. And you may not agree with it. You may say, no, that's in a minute. A second is a second, but it's a second. That's where the concept of reasoning about the case is. You may think ultimately that if somebody put a gun to your head, that he drove his vehicle intentionally into Deputy Weist, or that he drove with in such a manner that he had to have known that he would be causing death or great bodily harm. You might think that. That might be something you think of, but you're also going to think of what Sergeant Hughes said. It's possible he lost control of his vehicle. And the vehicle doesn't work on its own. He's got a steering wheel, he can try. But for you to conclude under that set of facts, driving at that speed on unsurfaced, on an uneven roadway surface, even the road itself, you see from the photos and the videos, it's cracked and a little bit worn. To say, to believe beyond a reasonable doubt that he had such control of his vehicle that he drove into Deputy Weist intentionally, I don't see how you can find that. And if you can't find it, you can't convict him of murder. Now, one of the other things that you will see in your instructions that you didn't know anything about until you won't know anything about it until I tell you about it, is that you're going to be given an option. The state's instructions, the state's charges of murder are going to be one option, but you're also going to get what's called a lesser included offense instruction. That's a procedure in the law that allows the judge, excuse me, as the jury, to find Mr. Rothman something other than what he's charged with. And I'm here to tell you today that you're going to get an instruction like that Mr. Richardson was guilty of aggravated reckless homicide. And I said it to you at the beginning of this case, and I'm going to say it to you now. This is only a murder case if you disregard everything about the mechanics and speed and the physics of this accident and just either feel sympathy or you know something about Mr. Richardson you don't like, then you have an option. You can find him not guilty of those murder charges because you feel there's a reasonable doubt as to whether he had it. You can do that. But you also, as an alternative, can find him guilty of aggravated reckless homicide if you find that he drove a vehicle recklessly. You're not going to hear me argue about that. You can't drive 100 miles an hour on a two-lane road, drive off the road, and not do it. So that's reckless. And that recklessness resulted in Nicholas Weist. Can't argue about that. So what I'm going to suggest to you, ladies and gentlemen, is when you go back and deliberate this case, that you come to the conclusion that it's just really unlikely that Daylon Richardson had the opportunity or the ability or the physical wherewithal to control his vehicle at that speed and that in a short distance absolutely confirms that. He didn't have time to form an intent to kill. He didn't have time to form an intent to say anything. Like I said, he was in pure flight or fright. Fight, it's harder to say than flight. But you can lie. And I suggest, and again, I hate to say that my client is guilty of anything, but if he is guilty of anything, he's guilty of reckless homicide, driving his vehicle recklessly that resulted in the death of another person. And I think you can conclude reasonably and beyond a reasonable doubt that is what occurred in this case, not a murder. As I said to you Tuesday, this is as serious a case as there is, but it's not a complicated one. It's only complicated if you somehow jump from the evidence that this was so fast and there was so little control involved that the state could never prove intent to kill or intent or the second version. And I'm going to talk about that in a second. The second version of intent to kill. The second version of intent to kill is like this. Count one, murder, intent. I aim a gun, shoot port. That's intent. That's murder. That's murder with intent. Count two, murder. Great possibility, high possibility, strong possibility of death as the result of the actions, of the intentional actions of the defendant. You may remember a few years ago, there was a gentleman who rented a hotel room in Las Vegas, got a bunch of AR-15s and AK-47s and other ammunition, went up in the room, and there was a country music concert playing in the strip below. He started firing. He just started firing. He didn't intend to kill anybody in particular, like I just intended to kill the quarterback. But the law says when you act like that, when there's a high probability that you're going to kill someone when you take intentional acts like that, That's murder just the same as if I aimed a gun. There's a case in O'Hare Airport 15, 20 years ago. Guy drove his vehicle. There's a whole bunch of people standing on there. And he says, I'm going to kill some people today. So he drove them into the crowd. He didn't intend to kill anybody to kill them. But his actions created a strong probability of death and great robbery. We don't have that in this case. We don't have that. We don't have Daylon Richardson doing something intentional with the idea of killing somebody. Daylon Richardson didn't wake up that morning, assuming he ever went to bed the night before. He didn't wake up that morning and say, oh, I'm going to go out and kill somebody today. No. He went to get gas at a gas station. Oh, and they find him there with a gun. And that starts the process. When did he ever form the intent to kill? Now, that's a rhetorical question, and I don't think answer it but for a different reason. You heard a lot of evidence over the last few days about the gun and that Daylon Richardson fired the gun. And when you hear the instructions, you're going to realize that act was not part of any of the charges that we're doing today. Court has admitted that evidence for reasons that are acceptable. You don't necessarily agree with them, but they're based on the law. So I have no way of arguing against that at this point. But why are we spending all this time with the crime scene investigator showing where bullets came out of the vehicle, or show the crime scene investigator and the people who collected the casings and tied it up to Mr. Richardson? None of that stuff happened. By the way, none of that stuff happened in Denton County. If Mr. Richardson indeed fired shots that day, they were fired in Knox Co. It's not charged that here. It's not in front of you today. Why do we hear so much about it? Because the state wants to dirty up Daylon Richardson. The state doesn't want him dealing with 160 feet. They don't want it. They want you to know, he had a gun, he shot, he's a bad guy, he ran over Nicholas Weist, killed him, tragic. That's not how you decide this case. You decide this case based on the evidence, not based on the fact that the state has gone to great lengths to prove that Daylon Richardson might not be the greatest human being alive. That's not what you should be doing. There's two more things I want to talk about. Number one is this whole issue of the second finding that you're required to make. You're required to make two more findings. If you find the defendant guilty of murder, you have to find two other things. You have to find that Deputy Weist was a peace officer in the course of performing his official duty, and two, that Daylon knew or should have known he was a peace officer. I'm not even talking about the second part, because that's all part of the evidence. We know what was in front of Daylon. We know that Daylon saw a police car. But did he know at the moment that he struck Deputy Weist that he was a police officer? 1.2 seconds. Is that knowledge? Or is that maybe? Maybe that's a police officer, maybe it isn't. He's got a uniform on, he's got a police car. I'm not going to fault you for making the finding for the state of that part of the case. Because there's pictures, there's people, we see them, we know. Not a, your local electrician doesn't go laying on stop signs. So I'm not going to argue that. However, was he in the course of performing his official duties? Sounds like a complicated phrase, no? Well, there's a famous passage in Through the Looking Glass, the book of Humpty Chalice and Wonderland is based, where Humpty Dumpty says, when I use a word, I mean only what that word means. Nothing more, nothing less. And you have to decide today that the state has proved beyond a reasonable doubt that Deputy Weist was in the course of performing his official duties that day. And I'm putting that extra emphasis on the word official, because when the legislature used the word official in describing this finding, it implies the opposite, which is there are some things that a police officer does that are not official. That's why they put the word official in there, because that's what you have to find, beyond a reasonable doubt. Not if you think it's official, it may be official, maybe not. You have to find that he was not in the course of performing his official duties. That's state of mind. Let's look at the evidence. Nicholas Weist is was a Knox County deputy sheriff. Where was he when he got the call? Was it in Knox County? He'd already left Knox County. He'd gone, somehow he ended up on North 150th Avenue, because at least as far as we know, from the squad car, he didn't determine from the time that he got the call to the time that he came to the fatal intersection. Never, once his shift was over, then he was gone. The shift was over, he wasn't in Knox County. He doesn't have any official capacity in any other county. And I'm going to take issue right now with Lieutenant Kramer's testimony about this whole 1042 thing. He's not 1042 until he calls it in, and he can wait all the way until he gets to his home outside of Viola, Illinois, which is somewhere between 20 and 25 miles from headquarters. So in theory, Nicholas Weist, and I'm not suggesting he did this, there's no evidence that Nicholas Weist was anything but a really good cop and a really good person. And the fact that all these people are here prove that. There's no evidence that he did anything wrong. But the policy, do you believe it? Some of you have worked for the government one time or another in your life, and some of us, like me, have been attorneys for governmental units. You did not see a written policy, a written program saying that an officer is not off duty until he calls himself off duty. Wouldn't that be nice to have a job that says you're going to pay me for 15, 20, 25 extra minutes based on my own practices and my own whim? That sounds ridiculous. That sounds absolutely ridiculous. And I'm suggesting, again, Lieutenant Kramer struck me as a bad person. Get that testimony. I don't know if it sounded contrived to you, but sure as heck sounded contrived to me. Ladies and gentlemen, it is a great honor being here representing Daylon Richardson in this case. This is the highest and best thing a criminal defense attorney such as myself can do. I've had a wonderful time doing it, but I greatly appreciate the service you provide. And I think in the end, when you get right down to it, you're going to say, this is reckless homicide. It's a bad reckless homicide, but it's a reckless homicide. But it's not. They cannot prove beyond a reasonable doubt that Daylon Richardson intended to kill anybody, no less deputies. Thank you.
Thank you, Mr. Herman. Ms. Franke?
Mr. Carmen has spent some time trying to convince you, most recently, that Deputy Weist was not acting within his official police capacity. He wasn't in the course of his official duties. I'm not sure how much more official police duties get, ladies and gentlemen, than stopping a fleeing vehicle, ensuring the safety of other citizens who are on the roadway. This is not a random person off the street who decided to insert themselves into a police chase. This isn't even a police officer who was at home at his kitchen table listening to the scanner and thought, oh my goodness, I'm close, I will get myself down there. This is a deputy who had just finished his assigned shift time. And contrary to what Mr. Carmen indicated, the testimony from the stand was that he was still within Knox County and on his way home when he heard that radio traffic. He's in uniform. He's in a marked police vehicle. He has on his police lights when he parks at the intersection of 150th and Route 150. And we know that because we can see them in the pictures and in the videos. They're still oscillating. Deputy Weist has been in contact with dispatch. He's asked for authorization from his supervisor. And once he's given that authorization, that's when he proceeds with deploying the stop strip. Official police duties. And then we have the defendant. Mr. Carmen has attempted to convince you that the defendant is not in control of the vehicle. And we know that isn't true. He had fantastic control of that vehicle because he drove it for 12 minutes from Galesburg at 100 miles an hour and managed to stay on the roadway that whole time until something got in his way. And then he had to make his decision, his fight or flight, and he chose flight. And how do we get around the stop stick? Just like Sergeant Kuhn explained to us, we can see the car as the marks from the car as it travels off to the right shoulder. And as it travels back on to the roadway. And then there's the evidence that he talked about from Deputy Weist's video from his vehicle. Where at that moment that it crosses over, you can see that the wheels on that Ford Taurus have turned to the right. Not continue to the left to try and get out of the way. No, we've turned to the right. That's one of those steering inputs that Sergeant Kuhn was talking to us about. And guess what else was to the right? Deputy Weist. Mr. Carmen would like for you to believe that the defendant didn't intend for this result to happen. We know that that isn't true as well. You're allowed to use your common sense here. You're allowed to make reasonable inferences. What could possibly be the intent of someone who is fleeing from the police at this high of a speed and firing shots? His intent was to not get caught, ever. And that's why we heard the evidence about the shots that were fired. And that's why we heard from CSI and we saw the diagrams about those, because that was real. That's part of his intent. That shows you what the end game was here. One of the other comments Mr. Carmen made was about the speed of the vehicle and that it must have been traveling so fast that we can't possibly have believed that the defendant would have made an intentional decision during that short period of time from when the vehicle goes off the road to when it comes back on the road. And I'm going to remind you one more time that that's not the evidence that's in front of you. Because Sergeant Kuhn sat here and explained to us very clearly, even though it was math and I can't with the math, okay, that he didn't have enough information to determine the speed. We know how fast the Galesburg car was going because we can see that in the bottom portion of that camera, okay? But that's the Galesburg car. And his testimony is he's doing his best to keep up with that Ford as it's fleeing from him. But the reality is we don't know how fast that vehicle was going when it got up to those stop spikes. And that Sergeant Kuhn explained to us that you're going to lose speed. No matter how fast you're going, you're going to lose speed when you go off the roadway onto that sticky surface, which was a phrase I liked, I hadn't heard it before, sticky surface. And then come back onto the road and we make those steering inputs. Those are all going to decrease our speed. Less speed means more time to make decisions. But you know what? This defendant had 12 minutes to make his decisions. Mr. Richardson was determined to get away from the police at any cost. We know that from the speed, we know that from the time of the chase. We know that from his decisions along the way. He initially attempted to avoid that stop spike by turning the car towards the right ditch and driving it through the grass. And here's the worst part, ladies and gentlemen. He could have made it. How do we know that? Because we watched. We watched the Galesburg squad cars. At the end of Deputy Weist's video, we watched them drive on their right-hand shoulder and through the grass around the stop spike. He didn't have to turn back towards the left, towards the roadway. He chose that. This defendant certainly could have avoided the stop strip and continued his flight from the police, but he made that steering input to the Ford, causing it to come back to the roadway, turning it to collide with Deputy Weist. And it's all there in the crash reconstruction report. I ask that you find that Deputy Weist was a peace officer who was killed in the course of performing his official duties, and that this defendant murdered him. Thank you.
Thank you, Ms. Renfrew. Members of the jury, the evidence and the arguments in this case have been completed, and I now will instruct you as to the law. The law that applies to this case is stated in these instructions, and it is your duty to follow all of them. You must not single out certain instructions and disregard others. When I use the word he in these instructions, I mean a male or a female. It is your duty to determine the facts and to determine them only from the evidence in this case. You are to apply the law to the facts and in this way decide the case. You are not to concern yourself with possible punishment or sentence for the offense charged during your deliberation. It is the function of the trial judge to determine the sentence should there be a verdict of guilty. Neither sympathy nor prejudice should influence you. You should not be biased in favor or against any person because of that person's race, ethnicity, national ancestry, religion, gender, sexual orientation, age, disability, or socioeconomic status. From time to time, it has been the duty of the court to rule on the admissibility of evidence. You should not concern yourselves with the reasons for these rulings. You should disregard questions and exhibits which were withdrawn or to which objections were sustained. Any evidence that was received for a limited purpose should not be considered by you for any other purpose. You should disregard testimony and exhibits which the court has refused or stricken. The evidence which you should consider consists only of the testimony of the witnesses, the exhibits, stipulations, and judicially noticed facts which the court has received. You may, but are not required to, accept as conclusive any fact judicially noticed. You should consider all the evidence in the light of your own observations and experiences in life. We all have feelings, assumptions, perceptions, fears, and stereotypes about others. Some biases we are aware of, and others we might not be fully aware of, which is why they are called implicit biases or unconscious biases. Our biases often affect how we act, favorably or unfavorably towards someone. Biases also can affect our thoughts, how we remember, what we see and hear, whom we believe or disbelieve, and how we make important decisions. As jurors, you are being asked to make important decisions in this case. You must resist jumping to conclusions based on personal likes or dislikes. You must not let bias, prejudice, or public opinion influence your decision. Neither by these instructions, nor by any ruling or remark which I have made, do I mean to indicate any opinion as to the facts or as to what your verdict should be. Faith and performance by you of your duties as jurors is vital to the administration of justice. We all have feelings, assumptions, perceptions, fears, and stereotypes about others. Some biases we are aware of, and other biases we might not be fully aware of, which is why they are called implicit biases or unconscious biases. Our biases often affect how we act favorably or unfavorably towards someone. Bias can affect our thoughts, how we remember, what we see and hear, whom we believe or disbelieve, and how we make important decisions. As jurors, you are being asked to make very important decisions in this case. You must resist jumping to conclusions based on personal likes or dislikes. You must not let bias, prejudice, or public opinion influence your decisions. You must not be biased in favor of or against any person because of his or her race, ethnicity, national ancestry, religion, gender, sexual orientation, age, disability, or socioeconomic status. Your verdict must be based solely on the evidence presented. Only you are the judges of the believability of the witnesses and of the weight to be given to the testimony of each of them. In considering the testimony of any witness, you may take into account his ability and opportunity to observe, his memory, his manner while testifying, any interest, bias, or prejudice he may have, and the reasonableness of his testimony considered in the light of all the evidence in the case. The fact that the defendant did not testify must not be considered by you in any way in arriving at your verdict. Opening statements are made by the attorneys to acquaint you with the facts they expect to prove. Closing arguments are made by the attorneys to discuss the facts and circumstances in the case and should be confined to the evidence and to reasonable inferences to be drawn from the evidence. Neither opening statements nor closing arguments are evidence, and any statement or argument made by the attorneys which is not based on the evidence should be disregarded. Those of you who took notes during trial may use your notes to refresh your memory during jury deliberations. Each juror should rely on his or her recollection of the evidence. Just because a juror has taken notes does not necessarily mean that his or her recollection of the evidence is any better or more accurate than the recollection of a juror who did not take notes. When you are discharged from further service in this case, your notes will be collected by the deputies and destroyed. Throughout that process, your notes will remain confidential and no one will be allowed to see them. The defendant is charged with the offense of murder. In parentheses, it says intent to kill or do great bodily harm. The defendant has pleaded not guilty. Under the law, a person charged with murder, in parentheses, intent to kill or do great bodily harm, may be found, 1, not guilty of murder, parentheses, intent to kill or do great bodily harm, and not guilty of aggravated reckless homicide, or 2, guilty of murder, in parentheses, intent to kill or do great bodily harm, or 3, guilty of aggravated reckless homicide. The defendant is charged with the offense of murder, in parentheses, strong probability of death or great bodily harm. The defendant is pleaded not guilty. Under the law, a person charged with murder, in parentheses, strong probability of death or great bodily harm, may be found, number 1, not guilty of murder, in parentheses, strong probability of death or great bodily harm, and not guilty of aggravated reckless homicide, or number 2, guilty of murder, in parentheses, strong probability of death or great bodily harm, or number 3, guilty of aggravated reckless homicide. The defendant has pleaded not guilty. The state has also alleged that when the defendant committed the offense of murder, in parentheses, intent to kill or do great bodily harm, and murder, in parentheses, strong probability of death or great bodily harm, the defendant murdered a peace officer when the peace officer was killed in the course of performing his official duties, and the defendant knew or should have known that the murdered individual was a peace officer. The defendant has denied these allegations. The charge against the defendant in this case is contained in a document called an information. This document is the formal method of charging the defendant and placing the defendant on trial. It is not any evidence against the defendant. The defendant is presumed to be innocent of the charges against him. This presumption remains with him throughout every stage of the trial and during your deliberations on the verdicts, and is not overcome unless from all the evidence in this case, you are convinced beyond a reasonable doubt that he is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the case. The defendant is not required to prove his innocence. The state has alleged that the murdered individual was a peace officer killed in the course of performing his official duties. The defendant is presumed to be innocent of this allegation. This presumption remains with the defendant throughout every stage of the trial and during your deliberations on the verdict, and is not overcome unless from all the evidence in this case, you are convinced beyond a reasonable doubt that the allegation is proven. The state has the burden of proving the allegation beyond a reasonable doubt, and this burden remains on the state throughout the case. The defendant is not required to disprove the allegation. Circumstantial evidence is the proof of facts or circumstances which give rise to a reasonable inference of other facts, which tend to show the guilt or innocence of the defendant. Circumstantial evidence should be considered by you together with all the other evidence in the case in arriving at your verdict. The term peace officer means any person by virtue of his office or public employment is vested by law with a duty to maintain public order or to make arrests for offenses, whether that duty extends to all offenses or limited to specific offenses. A person acts recklessly when he consciously disregards a substantial and unjustifiable risk that circumstances exist or that a result will follow. And such disregard constitutes a gross deviation from the standard of care which a reasonable person would exercise in the situation. A person acts knowingly with regard to the nature or attendant circumstances of his conduct when he is consciously aware that his conduct is of that nature or that those circumstances exist. Knowledge of a material fact includes awareness of the substantial probability that the fact exists. A person acts knowingly with regard to the result of his conduct when he is consciously aware that the result is practically certain to be caused by his conduct. Conduct performed knowingly or with knowledge is performed willfully. A person commits the offense of murder, in parentheses, intent to kill or do great bodily harm, when he kills an individual if, in performing the acts which cause the death, he intends to kill or do great bodily harm to that individual. A person commits the offense of murder, in parentheses, strong probability of death or great bodily harm, when he kills an individual if, in performing the acts which cause the death, he knows that such acts create a strong probability of death or great bodily harm to that individual. To sustain the charge of murder, the state must prove the following propositions. First proposition, that the defendant performed the acts which caused the death of Nicholas Weist. And second proposition, that when the defendant did so, number one, he intended to kill or do great bodily harm to Nicholas Weist, or number two, he knew that his acts created a strong probability of death or great bodily harm to Nicholas Weist. If you find from your consideration of all the evidence that each one of these propositions has been proven beyond a reasonable doubt, you should find the defendant guilty. If you find from your consideration of all the evidence that any one of these propositions has not been proved beyond a reasonable doubt, you should find the defendant not guilty. To sustain the allegation made in connection with the offense of murder, the state must prove the following propositions. That when the defendant committed the offense of murder, the defendant murdered a peace officer when the peace officer was killed in the course of performing his official duties, and the defendant knew or should have known that the murdered individual was a peace officer. A person commits the offense of aggravated reckless homicide when he unintentionally causes the death of a peace officer during the performance of his official duties as a peace officer by driving a motor vehicle recklessly and in a manner likely to cause death or great bodily harm. To sustain the charge of aggravated reckless homicide, the state must prove the following propositions. First proposition, that the defendant caused the death of a peace officer during the performance of his official duties as a peace officer by driving a motor vehicle. And second proposition, that the defendant drove a motor vehicle recklessly. And third proposition, that the defendant drove a motor vehicle in a manner likely to cause death or great bodily harm. If you find from your consideration of all the evidence that each one of these propositions has been proved beyond a reasonable doubt, you should find the defendant guilty. If you find from your consideration of all the evidence that any one of these propositions has not been proved beyond a reasonable doubt, you should find the defendant not guilty. When you retire to the jury room, you first will elect one of your members as your foreperson. He or she will preside during your deliberations on your verdicts. Your agreement on a verdict must be unanimous. Your verdicts must be in writing and signed by all of you, including your foreperson. The defendant is charged with the offense of murder, (parentheses, intent to kill or do great bodily harm). Under the law, a person charged with murder, (parentheses, intent to kill or do great bodily harm), may be found, 1, not guilty of murder, (parentheses, intent to kill or do great bodily harm), and not guilty of aggravated reckless homicide. Or number 2, guilty of murder, (parentheses, intent to kill or do great bodily harm). Or number 3, guilty of aggravated reckless homicide. Accordingly, you will be provided with 3 verdict forms pertaining to the charge of murder, in parentheses, intent to kill or do great bodily harm, a not guilty of murder, (parentheses, intent to kill or do great bodily harm, and not guilty of aggravated reckless homicide, guilty of murder, (parentheses, intent to kill or do great bodily harm, and guilty of aggravated reckless homicide. From these 3 verdict forms, you should select the one verdict form that reflects your verdict and sign it as I have stated. Do not write on the other 2 verdict forms for that charge. Under the law, the defendant cannot be guilty of murder, (parentheses, intent to kill or do great bodily harm, and aggravated reckless homicide. Accordingly, if you find the defendant guilty of murder, (parentheses, intent to kill or do great bodily harm), that would mean that the defendant is not guilty of aggravated reckless homicide. Likewise, if you find the defendant guilty of aggravated reckless homicide, that verdict would mean that the defendant is not guilty of murder, (parentheses, intent to kill or do great bodily harm). The defendant is also charged with the offense of murder, (parentheses, strong probability of death or great bodily harm). Under the law, a person charged with murder, (parentheses, strong probability of death or great bodily harm), may be found, number 1, not guilty of murder, (parentheses, strong probability of death or great bodily harm, and not guilty of aggravated reckless homicide. Or 2, guilty of murder, (parentheses, strong probability of death or great bodily harm. Or 3, guilty of aggravated reckless homicide. Accordingly, you will be provided with 3 verdict forms pertaining to the charge of murder, (parentheses, strong probability of death or great bodily harm, not guilty of murder, (parentheses, strong probability of death or great bodily harm, and not guilty of aggravated reckless homicide, guilty of murder, (parentheses, strong probability of death or great bodily harm, and guilty of aggravated reckless homicide. From these 3 verdict forms, you should select the one verdict form that reflects your verdict and sign it as I have stated. do not write on the other two verdict forms for that charge. Under the law, the defendant cannot be guilty of murder, strong probability of death or great bodily harm in parentheses, and aggravated reckless homicide. Accordingly, if you find the defendant guilty of murder, parentheses, strong probability of death or great bodily harm, that would mean that the defendant is not guilty of aggravated reckless homicide. Likewise, if you find the defendant guilty of aggravated reckless homicide, that verdict would mean that the defendant is not guilty of murder, parentheses, strong probability of death or great bodily harm. The state has also alleged that the defendant murdered a peace officer when the peace officer was killed in the course of performing his official duties, and the defendant knew or reasonably should have known that the murdered individual was a peace officer. If you find the defendant is not guilty of the offense of murder, you should not consider the state's additional allegation regarding the offense of murder. If you find the defendant is guilty of murder, you should then go on with your deliberation to decide whether the state has proved beyond a reasonable doubt the allegations that the murdered individual was a peace officer killed in the course of performing his official duties, and whether the defendant knew or reasonably should have known that the murdered individual was a peace officer. Accordingly, you will be provided with two verdict forms. Quote, we the jury find that the allegations that the murdered individual was a peace officer killed in the course of performing his official duties, and that the defendant knew or reasonably should have known that the murdered individual was a peace officer was not proven, end quote, and quote, we the jury find that the allegations that the murdered individual was a peace officer killed in the course of performing his official duties, and the defendant knew or reasonably should have known that the murdered individual was a peace officer was proven, end quote. From these two verdict forms, you should select the one verdict form that reflects your verdict and sign it as I have stated. Do not write on the other verdict form. Sign only one of these verdict forms. Your agreement on your verdict as to the allegations must be unanimous. Your verdict must be in writing and signed by all of you, including your foreperson. And I have the first verdict form of we the jury find the defendant, Daylon K. Richardson, not guilty of the offense of murder, parentheses, intent to kill or do great bodily harm, and not guilty of the offense of aggravated reckless homicide. I have the next verdict form that states we the jury find the defendant, Daylon K. Richardson, guilty of the offense of murder, parentheses, intent to kill or do great bodily harm. The next verdict form I have, we the jury find the defendant, Daylon K. Richardson, guilty of the offense of aggravated reckless homicide. Then I have the next verdict form, states we the jury find the defendant, Daylon K. Richardson, not guilty of the offense of murder, parentheses, strong probability of death, great bodily harm, and not guilty of the offense of aggravated reckless homicide. Then I have the next verdict form, we the jury find the defendant, Daylon K. Richardson, guilty of the offense of murder, parentheses, strong probability of death or great bodily harm, and parentheses. Then the next verdict form, we the jury find the defendant, Daylon K. Richardson, guilty of the offense of aggravated reckless homicide. Then I have the verdict form that says we the jury find that the allegations that the murdered individual was a peace officer killed in the course of performing his official duties, and that the defendant knew or reasonably should have known that the murdered individual was a peace officer was not proven. And then the last verdict form of we the jury find that the allegations that the murdered individual was a peace officer killed in the course of performing his official duties, and that the defendant knew or reasonably should have known the murdered individual was a peace officer was proven. So if I could have my bailiff step up to be sworn in, please.
Attend this jury in its retirement and keep them together, except by leave of court, that you will not speak to them yourselves, nor allow others to speak to them about this case. And when they have arrived at their verdict, you will bring them into court.
Okay. Where is Mr. Hoon? And where is Mr. Wyman? Mr. Wyman and Mr. Hoon, you are what we deem alternate jurors. So I know you sat with us all week, but you are not allowed to participate in the deliberations unless we need you. You are not discharged from jury service. I need you to give good contact information to Ms. Jeanette or Ms. Jane. Should a juror need to be replaced for any reason, then one of the two of you will be called back. So you cannot discuss this case with anyone. You can't go over any of the evidence, anything until either Ms. Jeanette or Ms. Jane call you to tell you that the deliberation or that there's been a verdict arrived. So thank you for being here all week. When you get back there, the two of you are allowed to leave, but you're not discharged until you get an official phone call from us. Do you understand, Mr. Hood? Mr. White, thank you. So here are the jury instructions, if I may give those to you. And we are going to stand in recess. According to my computer, it is 11:41, and that is when the jury is getting the case for deliberation. Keep them. I'm gonna take them home. And please be seated. Mr. Carmen and Ms. Runty, I'm going to assume that Ms. Terry Lynn has the ability to reach the two of you if and when we have a verdict today. Is that correct, Ms. Runty?
Yes, ma'am.
I'll be at the courthouse. I have a bond court thing at 2 o'clock, but I think that'll take 10 minutes. I'm hoping that we either don't or do have something done before then.
Okay. And then I'm going to leave contact people for your family, your responsibility to contact them when there's a verdict, Ms. Runty and Mr. Carmen. I'm going to leave you responsible for contacting your family, family, and Mr. Richardson, obviously. So we'll get a hold of everybody. So I guess hang out.
Items of evidence, documents, back to the jurors, Your Honor.
They're allowed to have it, but I can't, I mean, they were entered other than that last exhibit. Exhibit 28
Correct.
or what have you.
Are you going to go ahead and send those back to them now?
I usually wait until they ask for them, unless there's an objection. If you guys want me to go ahead and send it back to them.
I would prefer to wait.
I would prefer that they be sent so they have them to start with.
I'm gonna send them back. I'm gonna send it back, because I mean, by the time they track me down, and I track the two of you down and that stuff, so other than that last exhibit, because they were entered into evidence and they've been published, there's no sense in withholding it. Yes, take that one out, please. That's the only one. No, I have Hoon and Wyman as the alternatives. Did I not say Wyman?
No, you did.
Oh. Unless the attorneys are saying I'm wrong, but I wrote those two.
No, you had it right.
Okay, all right. All right, so we'll be in recess. Thank you.
Thank you.
I have to now as well. But I want to. Okay. I want you to.
and you can see as she pulls away, the tail light is well
Test check, 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 mic check, mic check. What do I do with my? Oh, right here. You And this is your TV6 Fastcast for this Thursday, February the 29th. Fresh food is coming to 5 Points in Davenport. DG Market on Division Street in Davenport is expected to open this spring. The former CVS is currently under construction and will become one of Dollar General's new DG markets that offer produce, refrigerated and frozen foods, dairy products, and fresh meat alongside its general goods. The company also said they're considering another store somewhere in Scott County. They expect to make a decision on that by summer of 2024. Speaking of summer 24, a special summer CrossFit competition is coming back to downtown Davenport. CrossFit OC3 and Daiquiri Factory got approval last night from Davenport City Council to close off a portion of downtown for 2 days to host the Summer Street Games. The event will run from 9 a.m. Friday, June 14th to 7 p.m. Saturday, June 15th. That closure will include West 3rd Street from Ripley to Harrison Streets. And that is your TV6 Fastcast. And this is your TV6 Fastcast for this Thursday, February the 29th. Fresh food is coming to 5 Points. DG Market on North Division Street is currently under construction right now to open. Oh, I'm just going to redo. All right. And this is your TV6 Fastcast for this Thursday, February the 29th. Fresh food is coming to 5 Points in Davenport. DG Market on North Division Street in Davenport is expected to open this spring. The former CVS is currently under construction and will become one of Dollar General's new DG markets that offer produce, refrigerated and frozen foods, dairy products, and fresh meat alongside its general goods. The company also said they're considering another store in Scott County. They expect to make a decision on that by summer of this year. Speaking of summer of this year, a special summer CrossFit competition is coming back to downtown Davenport. CrossFit OC3 and Daiquiri Factory got approval last night from Davenport City Council to close off a portion of downtown for 2 days to host the Summer Street Games. The event will run from 9 a.m. Friday, June 14th to 7 p.m. Saturday, June 15th. The closure will include West 3rd Street from Ripley to Harrison Streets. And that is your TV6 Fastcast.
I'm going to address the court members, everybody that's here. Everybody has been very respectful this entire time, and I truly appreciate everything that everybody has done following court decorum. I'm going to ask that everybody continue doing that, no matter what the verdict is. Please continue being your polite selves that you have been this entire time, and I'm very grateful for that behavior. So let's have the jurors come back in. Please be seated. We're back on the record. The jurors have been reassembled and indicated that they have reached a verdict. Who is the jury foreperson? Are you? And you have the verdict form, sir? Would you hand those to the bailiff so she can hand those to me, please? Thank you. I'm going to lose them. So I have the first verdict form that says, we, the jury, find the defendant, Daylon K. Richardson, guilty of the offense of murder, in parentheses, intent to kill or do great bodily harm. I have a second verdict form that says, we, the jury, find the defendant, Daylon K. Richardson, guilty of the offense of murder, parentheses, strong probability of death or great bodily harm. And the third verdict form, we, the jury, find that the allegations that the murdered individual was a peace officer killed in the course of performing his official duties, and that the defendant knew or reasonably should have known the murdered individual was a peace officer, was proven. Mr. Carmen, would you like the jury poll?
I would.
Yes, please. I can hear you better that way.
Juror number 59, was this then and is it now your true and correct verdict? Yes. Juror number 44, was this then and is it now your true and correct verdict to each count or as stated on the verdict forms?
Yes.
Can I go back into 59?
Sure.
Juror number 59, was this then and is it now your true and correct verdict to each count or as stated on the verdict forms? Yes. Juror number 81, was this then and is it now your true and correct verdict to each count or as stated on the verdict forms?
Yes.
Juror number 92, was this then and is it now your true and correct verdict to each count or as stated on the verdict forms?
Yes.
Juror number 73, was this then and is it now your true and correct verdict to each count or as stated on the verdict forms?
Yes.
Juror number 66, was this then and is it now your true and correct verdict to each count or as stated on the verdict forms? Yes. Juror number 22, was this then and is it now your true and correct verdict to each count or as stated on the verdict forms? Yes. Juror number 33. Was this then and is it now your true and correct verdict to each count or as stated on the verdict forms?
Yes.
Juror number 53. Was this then and is it now your true and correct verdict to each count or as stated on the verdict forms?
Yes.
Juror number 32. Was this then and is it now your true and correct verdict to each count or as stated on the verdict forms?
Yes.
Juror number 56. Was this then and is it now your true and correct verdict to each count or as stated on the verdict forms?
Yes.
Juror number 100. Was this then and is it now your true and correct verdict to each count or as stated on the verdict forms?
Yes. Thank you. Ladies and gentlemen of the jury, this concludes your jury service. Thank you for spending your week with us. I am very grateful for the service and that you appeared in court. Hope it wasn't a horrible experience and that, as I did this week, learned something new every day. So thank you again. So you are discharged from duty. And Jeanette or Jane, I'm going to ask you to call the 2 alternates and let them know they are discharged as well, please. So you're really... Please be seated. I believe I need to have a pre-sentence investigation report prepared and set this for a sentencing hearing. I don't know how far out your county goes because it's 45 days in my other counties.
45 to 60 days, please, Your Honor.
The verdict kind of limits what kind of a hearing we're going to have on sentencing. There will be a motion filed pertaining to that particular sentence. I would rather have that heard before we do a sentencing hearing.
I understand, Mr. Kerman. I would like to set the sentencing hearing out for 60 days. Once you file your motion, then we'll set your motion for hearing prior to the sentencing date. But because of my calendar, I have to get the sentencing hearing date on my calendar so that they're not moving me around to all different counties or my juvenile call in Rock Island County, I've got to clear.
The only problem, Your Honor, is the nature of the motion that I'm going to be filing is going to require me to assemble some medical records and such. That's going to take some time to get.
Okay. Well, then pick a date 75 days away. That gives you 2.5 months. So, and quite frankly, between your calendar and Ms. Runty's calendar, if I don't get a sentencing date today, between you, her, and me, we'll be doing a sentencing next year. And I'm not willing to do that. I want a sentencing date today, and then you have time to file and assemble whatever you wish to between now and whenever you want to file that, and I will certainly get the hearing in prior to the sentencing date. And then do I need to sign a pre-sentence investigation order? You don't do that out here?
They'll do that by docket, Your Honor.
All right. So Traylon, propose a date for me, please, about 75 days out. So that would put us at middle of May.
I have a 3-day trial in the middle of May, but other than that, I can work around it.
Can we start looking the week of the 20th, please?
Could you do any
Friday, May 24th.
That's fine.
It's fine.
Ms. Runty?
Yes.
Do you all want me to schedule this for a half day, for a day?
If we are planning sentencing only, not that additional motion hearing that day, I would say half.
Mr. Carmen?
I'll take a half day if the court's offered.
Per sentencing, only
Right.
because
Not because of motion, not for motions.
not the motion. No, the motion will be heard prior to that day.
So May 24th, anytime is fine.
Anytime, what time, what time? Sure, does 9 work?
Sure.
Ms. Runty?
That's fine.
So we'll set May 24th for 9 AM for sentencing. Mr. Carmen, get your motion on file. Somebody let me know that the motion was on file, because sometimes nobody tells me.
I'll send you a courtesy copy.
Thank you. And then we'll confer between the two of you and Ms. Terry Lynn to set the motion for hearing.
Yes, ma'am.
Okay,
It's fine.
all right. So we are adjourned. Thank you. What's the date today, Terry? Thank you. Yes, you'd think I would remember that. I know. I'm a horrible human being. I guess, I don't even know what day of the week it is.
You don't gotta rough.
I asked for no outbursts, and you have been very polite the entire week. And you did exactly as I asked you not to. I appreciate and I understand that it's emotional on both sides. And you are guests in my house. You follow my rules. If you don't like it, you don't have to be a guest. Am I clear?
Yes, ma'am.
Perfect. You are welcome back so long as you comply with my rules.
Yes, ma'am.
Thank you.